Hello and welcome to the Regulation Subcommittee of the California Paraprofessional Program Working Group. I will take roll. Hardston?
Here.
Sarouche?
Here.
Great, they're all here. You can see, do you want me to check to see if there's anyone who wants to make comment?
Yeah.
If there's anyone who's in the attendees room who would like to make a comment, please raise your hand. We have one person so far. Did you want to set a time limit for the comments?
Yeah, how about 3 minutes?
Okay.
3 minutes.
Okay. We'll start with Anthony Lai.
Hello, my name is Anthony Lai. I'm an attorney in Pasadena, California, and there was a program yesterday that was put on through the LA County Bar Association and a couple other organizations regarding the upcoming paraprofessional proposals that are going through the state bar. It's my understanding that there's been significant opposition to some of the proposals, as well as the suggestions to expand practice of the law by unlicensed persons. And I would ask that the committee take into account and really consider some of those concerns that are being expressed by members of the legal profession. It sounds like there's a lot of concern about whether these changes will reflect the best interests of the public, whether it potentially raises issues of liability and malpractice, whether these individuals are subject to the same ethical standards that attorneys are subject to, and just a lot of concerns. And I would really just ask that this board take into account some of those considerations that are being raised. Thank you.
Thank you. Howard. I think you're on mute.
Oh, yes, Howard Franco.
Yes, hi.
Oops. Sorry, Mr. Franco, I think I might have accidentally muted you. You want to unmute yourself?
Yeah, I've just tried. Can you hear me now?
Yes.
Okay, good. I'm an attorney, and part of my practice is representing attorneys. And I just had a couple of questions in terms of what your committee is doing. Number one, are you setting standards for paraprofessionals? In other words, lawyers have rules of professional conduct. Are you planning to set a group of rules for paraprofessionals? The second question I had is the program that you're considering going to have as part of its element a risk management component. In other words, are paraprofessionals going to be required or at least be offered professional liability insurance for the services that they, and then the third element is disclosures to the public regarding services provided by paraprofessionals. Are there going to be standards as to what those will be? And it comes up in the context of in the event that there is paraprofessionals recognized, what are their metes and bounds, and are there going to be at least some dividing lines, if not bright lines, between what is a paraprofessional authorized to do versus what a lawyer is supposed to do, so we don't have problems with the unauthorized practice of law. Those were my comments.
Thank you. Very apropos to today's discussion.
And I don't see any other raised hands.
Okay. So I think our main task for today is to prepare for next week's meeting and make sure we're all on the same page. I don't know if in addition, Greg, you wanted to potentially go back to some of those undecided policy questions, but maybe that'll come up as we're going through the material for the 19th. So happy to proceed however you all think makes sense. We could put up the draft memo. I saw, Amos, that you made some edits, which I haven't had a chance to look at yet, but we could put that up and kind of walk through it, make sure that that summary table is accurate. I think I inserted a question there, a couple of questions. Fariba, Amos, Greg, how do you think it makes sense to proceed?
I would like to go through the memo, and then that way we know what else we need to discuss other than what's here. It's much
Okay.
better.
Okay, Linda, do you mind screen sharing the Amos version that he sent to us just right before the meeting? Because I'm gonna take notes. So it's hard for me.
Sure,
to
I'd be happy to do that.
Okay.
I'm happy to talk through my comments.
Okay.
Okay, can everyone see that?
Yes, so, and thank you for putting this draft together. I'm not sure who is primarily responsible, although I have some guesses. My comments are really to the background section and the framing of the discussion. I think it's important that the full working group and the public know a little bit about the background of this subcommittee's work on regulation and the policy decisions. We have been tasked with making recommendations before jumping into the proposed rules of professional conduct, because I think the draft rules are obviously the end work product with Greg's and a lot of other input, but I think it's the higher level policy decisions on how regulation of paraprofessionals should work that I think we want to clarify what we decided and why. So in addition to this background, which I'll let everybody read, I think we should change the table to track those policy decisions as we have for prior reports from this subcommittee.
Okay, I don't think I would take any issue with your background additions. I think I wanted to make sure, but it looks like you changed this, that you and Greg and Fariba agree. I was trying to address this issue, Amos, that I think has come up on multiple occasions during our meetings, whether we are going to try to model or mirror the rules of professional conduct, or sort of take what I call the Washington approach, which is having a standalone set of rules governing the paraprofessional. And I thought it was important to explain that we chose the former. And so therefore we're sort of starting with the rules, right? And then seeing what modifications are needed, as opposed to starting from scratch. It looks like you changed that section. So maybe what I'm saying now doesn't need to be talked about.
So I think that's right. I think the Washington state model actually does both. They do have a rules of professional conduct for what they call triple LTs, in addition to, and maybe they're duplicated, but in addition to having kind of a clear set of rules in their rules of court. So with that slight change, I agree. I mean, I think it's sort of, from my perspective, what this committee did was it started with the policy decisions without regard to how they were going to be drafted or where they were going to be located. And then, you know, with the decision to track the rules for attorneys, I think, you know, we took on the big task. Again, thank you for a lot of staff work and Greg's work in going through all of the rules of professional conduct for attorneys. But I'm just really trying to frame it that we made policy decisions first about regulation of paraprofessionals, and now we're sort of modifying the rules to track those policy decisions. But I did leave in your language about the decision to track the rules, track the approach in California for attorneys as opposed to what other states have been doing for paraprofessionals. And I'm totally open to any edits to make it more clear. I was really just trying to take a step back at the subcommittee's work.
The one thing I might say, and I think we've mentioned this before, but so we're envisioning the written agreement, retention agreement requirement and the informed consent requirement to be two separate requirements, right? And that's how they're laid out in the draft rules that we have right now. I'm noticing here it says requirements for written agreement and mandatory disclosures. The written agreement does include mandatory disclosures under the rule. And then there's also mandatory disclosures under the informed consent rule. So just to, I don't know, how do we clarify, if we clarify that requirements for a written agreement, including mandatory disclosures, and a requirement for informed consent. One of the issues with the informed consent rule that I think I touched on last time, and it's the more I thought about it, it's something I think we need to probably put a little bit more attention on, which is what is the triggering event that imposes this obligation on a paraprofessional. The written agreement is it's clear. The triggering event is before you can enter into a retention, a representation relationship with a client. You need to have this written agreement in place that includes mandatory disclosures as we set forth in the rule. But informed consent, the informed consent rule seems to contemplate something, a set of mandatory disclosures that a client has to sign off on earlier in the process. And so we may want to do some thinking, and it may be something that we can talk about with the larger working group. We're also going to have, by the way, not only Professor Moore at the meeting on Monday, but also Mark Tuft, who was also on the Second Rules Revision Commission. He co-authors the Rudder Guide and Professional Responsibility with Professor Moore. So we're going to have a lot of firepower there to help us sort through some of these issues. But the reason I think informed consent may be confusing to some people, especially those that know the rules of professional conduct for lawyers pretty well, is that there is an informed consent requirement attached to many different rules in the RPC. So, for instance, if there's a conflict of interest that's waivable under 1.7, you need to obtain informed consent, and that's a defined term. So that's all a big windup to say, should we provide a little bit more information about what we mean by informed consent?
Do you mean,
Sorry, go ahead.
are you referring, Greg, because I'm looking at, I'm actually just have Amos's memo up. So sorry,
Yeah.
I'm taking notes. Are you talking about the second paragraph in the background section on several issues, including?
Yes.
Okay.
Yeah. So 1 says requirements for a written agreement and mandatory disclosures, and 2 says a requirement for informed consent. And I'm wondering if we need to, and it may need to be reflected in the draft rule that we end up proposing, but something like pre-representation informed consent, or something that indicates what type of informed consent we're talking about that's different from what's in the current rules for lawyers.
So I remember this conversation from last time. We didn't go too much into it, but we talked about how, at the stage where the client is ready to hire the paraprofessional, there's been so much conversation and exchange of information that at that point, the client may have a difficult time to back off after reading the information in the informed consent. So they will go ahead and sign anywhere. That's what I remember. And I think we talked about it at one other time previously, but I agree that informed consent should be a document that is given early on at the intake level, the very first meeting before there's exchange of information, so that the client is informed of who they're talking to, and at that point can make an informed decision of, I really wanted to talk to a lawyer, whatever goes through their mind. But you said, Greg, that the problem is that the attorney rules have a requirement for informed consent in different sections. Could you give me an example? I'm just blanking out on that.
Sure. Well, we talked about Rule 1.8.1, which is when a lawyer enters into a business transaction or obtains a pecuniary interest adverse to their client. And there's certain client protections in that rule, such as the terms need to be fair and reasonable. They need to be in writing, provided in writing to the client. The client needs to be able to obtain independent counsel, given an opportunity to obtain independent counsel, or must be represented by independent counsel already. And they must provide informed consent. That's one example. Another example is just a pure conflict of interest under Rule 1.7. If a lawyer or their firm is representing a client and another client who has an adverse interest to that client, it may be a waivable conflict.
Yes.
But you need to actually provide the required disclosures about what the potential conflict may be and obtain informed consent under those circumstances as well.
Okay, I got it.
There's
Okay.
a
And you don't
number of
want the
ethical
two to be
rules in which-
confused.
Yeah,
You don't want
there's
this to
sort
be
of ethical
confused with
rules in
the-
which
yeah.
informed consent is required in order to continue representation. And that's why the word informed consent is actually a defined term under Rule 1.0.1, because it's used so often in the rules of professional conduct. So to say that we're including a requirement for informed consent may be confusing, especially for the people who really know the rules very well, because they're going to say, of course, informed consent should be required when it's apropos. But what we're saying is a different type of informed consent that's not required of attorneys. Attorneys are not required to sit down and say, I'm an attorney, this is the process for becoming an attorney. But we're requiring paraprofessionals to say, I am not a lawyer, and this is the limited scope of practice that I can practice in, and all the other things that you included in that rule, which I think is appropriate and will protect the public. But I think we just need a little bit more description around what informed consent we're talking about, if that makes sense.
So
So
I do.
that pre-representation is what I was just thinking at the top of my head. Sorry, Amos.
Yeah, no, and thank you for this clarification. I think it's a great idea, and to avoid confusion and to make it as clear as possible, I'm definitely open to your suggestions of how we frame it. I think the important thing is that we discussed and agreed that this informed consent requirement, distinguishing it from others, requires the paraprofessional to inform the prospective client of the risks and alternatives to engaging the paraprofessional. So that is pre-engagement. We decided it does need to be in writing, and we still are working through if that should be a form or the standard things that it should include. But if there is another way to term it or to frame it or to explain it, I would very much like to avoid confusion, not only with other informed consent requirements in the rules of professional conduct, but also with our separate recommendation of a written agreement and mandatory disclosures, because we also discussed and agreed that this should be separate and not confused or combined with that.
So I'm wondering if a fix is to say, or a modification in one, requirements, I've just put for a written agreement and mandatory disclosures. I understand, Greg, they're not one and the same, but I think that it's okay that they're in the same number. And then two, requirements for pre-engagement informed consent.
I like that.
Yeah, that's good. And instead of saying written agreement and mandatory disclosures, I would say written agreement including mandatory disclosures.
Sounds good.
All right.
I could think of one place where attorneys do this, where collaborative law attorneys have to get clients to sign off on a document that says you understand that if you want to litigate, we sub out, we don't litigate. And I don't know if that's the rules. It's probably not a rule of professional conduct, but it's
No, that's a creature of contract, really.
yeah.
But
it is based on conflicts of interest, because they're effectively representing both sides.
Yes, that's true. That is true. So one good example, Randy DeFenturum pointed out yesterday when we were talking about this, is the mandatory fee arbitration program, lawyers are required to provide a disclosure about that program to clients.
Mhm.
And that's maybe an example of these what are we calling it? Pre-retention?
Pre-engagement.
I'm sorry?
We called it pre-engagement.
Pre-engagement. Okay, pre-engagement informed consent may be something that we standardize as a form that they need to provide and obtain the consent of the client from before they can proceed with intake or talking to them about their matter. And it may be something when we really get down to the rules, because we have certain duties attached to duties owed to prospective clients under our new set of rules. It may be an appropriate area where we cross-reference this requirement to obtain in pre-engagement informed consent.
Sounds great.
Okay.
So then, Amos, your comment on the table, you want to add in all of the other decisions that have been made, like on the CLE, on the bond. Is that what you're referencing here?
No, I don't mind if those have been separately dealt with previous resolutions. I'm talking about in each of our prior reports as a subcommittee, it talked about the policy decisions. It's not comparing it to the lawyer rules. It's a decision about regulating paraprofessionals. And again, I don't want to start from the position that all regulations of paraprofessionals should be the same as regulations for attorneys, and we have to justify the difference. That's not how we did it. We first started with regulation of paraprofessionals and made policy decisions about things. And I'm just reading from our prior report, continuing legal education, financial responsibility, written agreement and mandatory disclosures, informed consent, scope of practice, advertising limitations. We made those decisions, and then we turned to the rules of professional conduct and decided where we needed to, revise them, amend them, delete them. So I just think this table sets us up to, I think incorrectly frames the work that we did in trying to set it up as, justifying or explaining differences for the rules of professional conduct, which we are providing a red line of the rules, and we will be able to talk about and address any questions for why we're recommending changes to the rules of professional conduct.
Amos, do you think that so below the table, the different numbered questions that are a bit more in narrative form, which I initially drafted, and Leah has, I think, put it into a more user-friendly form, but this I think reflects the policy questions and decisions that you made as a subcommittee based on the policy issues that I brought to you. Do you think this accurately reflects the process you went through?
So yeah, we just got this right before,
Yeah.
so I haven't really gone in that detail, but I don't mind the format of it. And I know the rules that we've looked at do reflect, so I don't think there's any issues or concerns here on the substance, although I would like to review it more carefully. I don't mind this presentation. Again, what I would recommend is, again, rather than a question, it's a question and answer. It's a policy decision that we made. So paraprofessionals need to make, rather than whether they do or not, it's, I would frame it. But again, if you want to frame it as a question and answer, I don't mind. But I think, and Fariba, please weigh in here. I think basically we decided, and we heard from various people. We considered the various rules. We looked at how other states are doing it. We went through a lot of process, and we made the determination that paraprofessionals need to. So yeah, this is two separate things combined. I'm just looking at it. So disclosures and informed consent. I see this is part of the issue you were just raising. This is confusing, I think. Might confuse a couple of different things. The written agreement, I think it's very important that we separate our decisions on written agreement and mandatory disclosures in the written agreement from the separate requirement of pre-engagement informed consent. So that might be a different distinction, but otherwise I don't mind so much if you want to do a question and answer as opposed to, just our policy decisions.
Well, the way I ended up creating that list of policy issues that I wanted to bring to you was I actually did go through the lawyer rules and try to identify the major policy decisions undergirding all of the rules and tried to surface those so that you could make a policy decision around that, whether or not we want to apply a similar sort of prohibition or restriction or provide the similar guidance that we provide to lawyers as we do to paraprofessionals. So I think that's one of the reasons why I set it up as a question and answer, because I sort of presented it to you as a question and answer. The issue with disclosures, again, I mean, it's funny to me because actually every informed consent requires a disclosure. So, and we have disclosures as part of the written agreement too. So maybe we don't need to bold and italicize disclosures here, because what we're really talking about is the pre-representation informed consent. But that's the reason why I put it in a question and answer, and then tried to provide some background on what your policy decision was in this regard.
Right, but
Can we go back? I'm sorry, I just want to make sure we go back to the table, because I do think Amos, as Greg mentioned, I do think there was some basis or starting point in the rules, not a purely blind exercise of just taking the policy question, absent any tie to the existing rules. But two, the reason this was my idea to create kind of a table that's really succinct, that doesn't include a bunch of narrative, because you've got a bunch of narrative below. And I think that there is some value in having sort of a Reader's Digest guide to, is this going to be required? Yes or no? And if I'm a lawyer, right, we're sort of assuming that at least lawyers that review it have some familiarity with their own rules. And so that it is a helpful digest point to compare and contrast to the rules that are in place for lawyers. So that was my thinking, is like just a quick snapshot. We could take it out altogether. I do think it will lose its value if we put in much narrative explaining the policy rationale, because then it's not really, a snapshot. Then you get into what you've got below. So I just wanted to provide that bit of context for the table.
So my view, I don't feel very strongly about this, but my view is, I do agree, Greg, that that's how you approached it, and that approach has been very helpful. But I don't believe that's where this subcommittee started. So I think we started with a broader charge than just for drafting the rules of professional conduct. And we did look at some preliminary questions, both reflected in the ADLS report. If you remember, the first thing we did was we looked at ADLS and went through which ones of these fall in the regulatory committee's purview, which fall outside, address some of those, high level issues like mandatory legal education, which is not part of the professional rules of conduct, and looked at some other high level issues. And then we, in my opinion, we use this because we decided with various suggestions and input to draft a parallel set of rules of professional conduct. Then going through the rules and seeing where there should be changes was obviously an important exercise, and informed our decisions and came up with some additional questions. But I don't think, at least my opinion is, we shouldn't have and didn't start with assuming that paraprofessionals would be regulated exactly the same as attorneys. And I think framing it with a table that starts with explaining where there's differences and similarities is just standing the process a bit on its head and making us justify why this new licensed paraprofessional should be treated any differently than attorneys, as opposed to what we actually did was look at some critical high-level regulatory issues, consumer protection issues, made some decisions, and then went to the rules of professional conduct for attorneys to see if there's any other differences or other issues that need to be addressed, and identified several. So there's a lot going on, but I still think, you know, the main issue is we're starting with five or seven high-level policy determinations we decided on how paraprofessionals should be regulated before digging into, you know, what's the language going to be, where is it that going to be located, should it be in the rules of court, should it be in the, you know, professional rules of conduct, should it be in proposed legislation. So I think this is an important distinction, and I don't want to bury our policy decisions because I think that buries sort of the important part of what we're doing.
Okay. I agree with you in terms of the process. I don't see that you're burying your policy decisions, but I guess in order to move this conversation forward, should we then remove the table and take a different approach? And if so, what is the approach that you're recommending?
Could I jump in here for just a moment? I think people learn differently. I think a table is helpful in my opinion. I also think it's consistent with the other committees because I'm in like 3 committees, we have tables. And I think if once we present a final plan, that would be helpful to have one. It's also easy to read and easy to kind of figure out where is what versus a narrative, you have to get into it more. So I would, you know, my opinion is to keep it. I think the format of the narrative really makes a tough to understand topic understandable in the way it's organized. I was just wondering, instead of saying question 1, we could call it recommendation as to each one, because that isn't that what we're recommending as a committee?
So Fariba, I 100% agree on all points. So I think the chart or table is helpful. I just wouldn't focus the chart on showing differences or similarities with attorney regulation. I would focus it on the policy
As
decision.
a practical matter, then you recommend eliminating the last column?
Or changing it to, yeah, I can forward I can quickly. We did a chart in each of our last reports.
But that's a question that's going to be on almost everyone's mind.
Yeah, I think so.
You know, so why hide it?
The differences between the lawyer rules is going to be top of mind for many members, and many.
It has been almost in every discussion. I mean, I've been asking that question. Maybe that's my thing. I don't.
I agree. There's several people on the working group who have started from the position, let's not regulate paraprofessionals differently than attorneys. Let's just use the attorney rules. That's not how I approach this, but I agree. We shouldn't hide changes or recommendations that change. So I think we're providing a full red line of the professional rules of conduct for attorneys, red line to show changes. And I don't mind we certainly don't want to hide those changes. If there is a table discussing those changes, that's fine too. I just I wouldn't frame it that that's how we started. And I wouldn't frame it that we have to defend every change from attorney rules, because we're proposing the creation of a new licensed paraprofessional. They are not attorneys. They're not regulated by the attorney rules unless we decide to propose that.
I know I started with that question. You know, I do remember thinking, you know, if the answer is no, we're not going to regulate them differently, then we're done. I wanted to know, you know, to what extent we're going to treat them differently.
I don't think anyone said that we are going to regulate paraprofessionals exactly like we do attorneys. I mean, realistically, that was never anyone's position. And I will tell you that the court is going to want to know if we're regulating paraprofessionals differently than attorneys, the reason why. Not that it wouldn't be a good reason, but the reason why. And there's always a policy decision underlying that difference. And so I think it's fine if you want to approach it this way. I think when the rules get presented to the court, we will be highlighting the differences between the lawyer rules and the paraprofessional rules and why they're different and why they're the same. And some of that has to do with the limited scope of practice. There are certain rules that just simply won't apply to paraprofessionals. And there's others because there's other decisions that you've made to impose additional obligations on paraprofessionals in the interest of protecting the public. And those, you know, there's solid rationale for that as well.
And again, I don't want to appear too stubborn about this, but I do think at least at the full working group level, at the public comment level, and at the State Bar Board of Trustees, I think there is a lot of people who have the opinion that less regulation is better, and there's already a system of regulation for attorneys, so let's follow that. So maybe the Supreme Court won't take that approach, but I do think we are making recommendations and we have to justify our recommendations, and it's sort of just a framing issue that I'm concerned about. But again, if you have a strong feeling about this, I certainly am happy to defer to you. But I think that's how we frame the discussion. And if it's going to be both for public comment and for the full working group, I do think, at least my sense in the last several meetings where this has come up, is there are several people who just want to apply the attorney rules.
And then one new thing is that now we've voted on allowing paraprofessionals to do full representation as a default position of the working group. So I think that's different.
Full in court.
Full in court representation. I don't know what I said, but anyway, and that may justify to a certain extent having to treat them the same as attorneys, because that in court representation is a huge deal.
Yeah.
So I think that's one new element that we have to add to our considerations and recommendations.
Yeah, and anyone that took the position that all the same rules will apply to paraprofessionals just are not paying attention to what this program. I mean, paraprofessionals are not representing clients in criminal matters. We've taken that off the table immediately. There are a number of ethical rules that only apply to prosecutors or only apply to people that are involved in criminal cases. So right off the top, we've taken a bunch of rules off. And then there's several others that simply don't apply. I mean, so for instance, drafting an instrument to provide a substantial gift to the paraprofessional or a relative of the paraprofessional, we're not authorizing them to draft those types of instruments. So that rule is gone. So there's a whole set of rules that absolutely have to come off the top. So you can't say that the same rules apply to paraprofessionals that it will apply to lawyers. We know that's not true. But then there's some additional rules that you want to have apply to paraprofessionals, and that's what we're trying to reflect here. I think the best way to move forward, though, is to really just talk about how we should change this table so that it's accurately reflecting what you want it to.
Yeah, so I think that's very helpful. But again, I think it's not so much that there are some that just wouldn't be applicable. What I'm focused on is there are certain consumer protections that we are recommending that are not required for attorneys that we are recommending for paraprofessionals. So if we just start with the attorney rules and have to justify those, it's just a framing starting. I'm not disagreeing that certain rule. I just don't think there would be debate about rules that are inapplicable. I think the issue is, providing consumer protections for non-attorneys practicing law.
Understood. And I think that's what we're trying to convey in this table, but it didn't work. So again, what do we need to do to the table to make it reflect what you want it to for the group?
Well, I like Fariba's proposal, which is instead of framing these as key question issues, questions, changing them to our recommendations.
Okay.
So in the table header and then throughout the document.
Right.
Okay. Do you also, though, recommend eliminating the last column? But it sounds like Fariba, you perhaps disagree with that. Sort of the reference to the attorney rules.
I agree that it's helpful to leave it in.
So it seems like the first two columns can just be melded into one recommendation because you don't need an answer if you don't have a question. And then I would also take out that first row, disclosures required. That's meaningless to me. So disclosures, there's disclosures in the informed consent and there's disclosures in the written agreement. So you might take out that first row and say, what did we call it? Pre-engagement informed consent required with mandatory disclosures. And written retention agreement required with mandatory disclosures.
Okay, so merge the first two columns and make it like a statement stating what the recommendation is.
If that's what Fariba and Amos agree with. I mean, you don't need a short answer if you're not posing a question. So
No, I got that.
yeah.
So Amos, do you think that would be sufficient? Because when you're referring to the other tables we've done, sometimes there is a bit more narrative and substance to them in those tables. And that's what I'm trying to avoid, simply because this list is so long. But if we'd say, yes, advance fees are allowed. Unearned advance fees are not allowed. Basically, taking them and creating statements.
Yeah, and will there be, yes, that's a good idea, because there will be a narrative as well, right?
The narrative is all the rest of this.
Yeah, so I agree that this should be as brief, the explanation should be as brief as possible.
What do you think, Amos?
Well, honestly, my concern is with the third column, again, setting us up to be on the defensive and justify changes. I don't like that. I don't think that reflects our work, but I defer if Fariba and Greg think that it's helpful and that it won't serve as a significant obstacle to getting this past the working group and the Board of Trustees. It's obviously interesting and helpful and something that people will look to. I just don't know that that's the best way to start.
I guess I have a different take than you. I'm not feeling like anybody will be on the defensive for having more restrictive rules. I think there may be some being on the defensive for the few that are more permissive, which touch on some of the hot button issues around non-attorney ownership. But I guess I'm feeling like generally there's a desire to impose a number of restrictions on these new paraprofessionals. So I guess I'm not seeing that this would result in a need to justify, maybe I'm reading the room incorrectly, but that's not been my sense.
Okay, I will, if all three of you agree, I will defer to you.
All right, so I will work on revising that. Greg, just for my own edification, I want to understand this. I realize I'm looking at a different document than you all, but can paraprofessionals and lawyers in different firms split fees? And our answer in the table is yes, recommendation is yes. And then whether it differs from the attorney rules, right now it says same. Yeah, but I didn't think that was allowed now, because the equivalent would be lawyers and non-lawyers splitting fees.
Yeah, and I think I sent you a note about, because I sent you, I wouldn't say same, I would say different, although the client disclosure requirements are the same. So obviously this is different.
Yeah, okay, good. All right. Okay.
Because we don't have paraprofessionals and lawyers splitting fees from different.
And do we allow lawyers and non-lawyers, say a lawyer and an accountant? Is that allowed now? No. Okay, so it is more permissive than the current status quo, what we're proposing.
Arguably, yes.
Okay, all right. Linda, did you
say arguably because what you're talking about is splitting fees among licensees of the state bar, which right. Wouldn't necessarily be unless they were also a lawyer.
Right. Linda, did you say there's someone who wants to make public comment now?
Yes, there is. Oh, that person is gone and out. That person has lowered their. Oh no, he's back. And Ira Spiro. So I'm wondering if we should call on Joshua Lee, because I think he had his hand raised for a while and then sort of maybe gave up. So should we allow him first?
Fariba, Amos, is that okay with you?
Yeah, great.
Okay.
That's fine.
Okay. You're muted, Mr. Lee.
Hello, my name is Joshua Lee. Can everybody hear me? Is that? Thank you. All right. My name is Joshua Lee. I'm on the board of CALDA, the California Legal Documents Assistance. Regarding disclosures and informed consent, right now our contract is, the contracts that we have contain required language in terms of all the things that I think you guys are kind of looking towards in terms of informed consent for potential clients. We have to state that we are not attorneys. We cannot give legal advice. Our websites, any websites that we have to contain that language. Any business card, any kind of advertising information, we had to be very specific that we are not attorneys. And so I wonder if the working group could look at that the state's already using legal document assistance and their statutory required language as a model for licensing of paraprofessionals. Thank you.
Linda, does somebody else have their hand up?
Yes.
Ira.
Hi, Ira.
Hi. About the resistance to change in the rules and the title of the words in the right-hand column. Yesterday, I was at a seminar by some of the people we already know about from the various plaintiff bar organizations. I think it was all plaintiff, yeah. And put on Beverly Hills Bar. Anyway, there were some statements about, they're changing the rules of professional conduct. And then I tried to, anyway, statements that they're changing the rules of professional conduct. And then a statement we've heard before in one of our meetings that, there's been so much study, the ABA and the California committees did so many years of studying on the rules of professional conduct. And now for this working group to change them, so I think that'll get repeated a lot. And I see these not as changes to the rule of professional conduct, though literally they are, but I see them as adaptations of the rules to make them apply correctly to paraprofessionals. And I think I would use the word adaptations in the right-hand column. And then as far as the words below the title, I don't know that they're very, I think they're not very helpful. That is very instructive. In other words, when you see different, you see the same, you really don't know what that means, because like you all were discussing just a few minutes ago, when it says the same, when it says different, it's ambiguous, because if you consider that paraprofessionals are now going to be treated as lawyers to a limited degree, then the rule is the same. But if you consider that we're adding paraprofessionals to what is allowed, for instance, fee sharing, then it's different. So rather than say different or the same, maybe just a quick explanation, like what's in that very first row. Well, maybe a little bit more than that. For instance, when we're talking about fee sharing, allows fee sharing for paraprofessionals as fee sharing is allowed by lawyers, something like that.
Thanks, Ira.
Thanks, Ira.
Okay.
All right, so I definitely will try to take another stab at the table, see what I can come up with. Do we want to go through the rest of the memo?
I'm leaving that up to then, Amos.
Yeah, we could also, I mean, it would be a little bit unusual, but I know that you all just got this, and it would be great to get something finalized today-ish, tomorrow-ish, so that we could get it posted and we give the working group members a real opportunity to review the material. So we could take like a 30-minute break right now and give you guys time to actually read the memo. I think that that would be fine. So I'm open to what you'd like to do. We could also just talk about the presentation on the 19th as a staff team, and then with Professor Moore and Mark Tuft. We all met yesterday, I guess that was, to talk about how we think this aspect of the meeting on the 19th will go, but we haven't had a chance to talk about that with the two of you in terms of the actual PowerPoint, the presentation, the discussion. So we could do that now as well.
That would be helpful.
Okay. So I think, and Greg, jump in if I say anything incorrect, that what we thought we would do is focus on the issues in the table, starting with those that we think are the most controversial. And maybe we can spend some time flagging those now, just so that we make sure we get to them, and that there would be some teeing up of the issue, basically some of the material that's provided in the narrative portion of this document. And that would be done by Greg. But then for you, Amos and Fariba, you would then speak to here's our actual recommendation, and speak to the rationale for why it is so. So, so basically, I think there's like 21 21 issues outlined. So we would put them in order, as I said, of controversy or significance, perhaps, rather than in the order in which they necessarily appear, and then proceed in that fashion.
I will just say that probably the big hot button issues are those under relationships with lawyers. And that doesn't start until question 17, or we'll say recommendation 17, I guess. So because I think the big hot button issues are going to be whether or not paraprofessionals can have an ownership stake in a firm, and whether or not they can share legal fees with lawyers who are in different firms than the paraprofessional.
And I'm sorry, this is Joanna jumping in, and I had to step away, so I'm sorry if you just reviewed this again. Are we keeping an eye on the overlap between this committee and the other state bar working group in regards to that issue of ownership?
Yes, and I think I had mentioned to you, Justice Patru, that after Carolyn's request, I'd reached out to Mark Tuft to ask him to present, or to be available to present on Monday, and he is going to be there. So before we even launch into this deep dive into the rules, and perhaps we should step back, Greg, with kind of an overview of what we discussed. Mark will give an overview of the ADL's recommendations that are relevant to our discussion, as well as the closing the Justice Gap Working Group charge. Mark or Kevin, who's actually on the working group. And then we've asked them, as well as Randy and others, to speak to this question of whether or not the fact that closing the Justice Gap Working Group is considering some of these issues, how that should, if at all, inform the work of the working group.
Well, yeah, because that's my concern, is that I thought this particular question was kind of within, and I could be misremembering their charter, but I thought it was clearly within their charter and not so clearly within ours. So I just want to be very careful that A, we're not take on work that's been clearly designated for others, and that B, we not take on something that we don't need to, since we have plenty.
Well, it is within the Closing the Justice Gap Group's charter to decide whether or not there are any changes necessary to the lawyers' rule 5.4, which would allow non-lawyer ownership of firms or sharing of legal fees with non-lawyers within a firm. So there is an overlap there to the extent that this group is going to recommend that paraprofessionals and lawyers can co-own a firm, and the regulatory subcommittee is recommending that be allowed as long as the paraprofessionals don't own more than 50% of the firm. It requires us to touch
Right.
5.4. There's no way we can enable that without not
Well,
only editing.
so I guess this subcommittee would need to be ready to answer the question of why are we doing this, right? Why is this recommendation happening at this point in time, understanding that the Closing the Justice Gap Working Group is focusing on, it's one of the issues that it's clearly focusing on, as opposed to putting in place the paraprofessional program, with the possibility, depending on what happens with the other working group, of ownership being something possible down the line. And I raise this because it's not that ownership's not necessary for the paraprofessional program to move forward. So for example, with the experiential hours, a paralegal could work at the firm and, not be paid or whatever, and not be a part owner. I guess the question is it the point of view of the regulation subcommittee or the working group as a whole that unless this incentive exists to be able to be up to a 50% owner, that people aren't going to go into it? Like, why are we doing this? Are we doing this in order to incentivize people to become paraprofessionals? I would like to know the answer. I'm not asking you to answer me right this minute, but I think the question is going to get legitimately raised in the working group as a whole of why are we doing this at this point in time?
And I'd just like to add that this is another example of where starting with the policy decisions that we discussed and made makes sense to me in framing the discussion. If we start with the rules and a red line of the rules and how it's different than attorney regulation, I think it gets us in this defending why we're touching this at all. And the working group might not agree with us and may not follow our recommendations, which is totally fine. But I think our recommendation isn't just we want to modify these rules and we're recommending it. It's we're making a policy decision about ownership, about recruiting, about paraprofessionals being able to work in their own firms and own them, and also have an attorney in that mix. So you could have 3 paraprofessionals and an attorney doing a firm. And that's the discussion that I think frames it, as opposed to just jumping into Rule 5.4.
No, and I agree with you, Amos, and I think it needs to be framed, but I would expect, and I'm not saying what my view is on this, I would expect significant pushback of why are we tackling this when a different working group has been established and they've been clearly directed to think about this issue.
So
I agree.
Just,
And I think we'll get the same pushback on some of the other consumer protections that we are recommending specifically for paraprofessionals that aren't built into the rules for attorneys. And so I think that's this whole regulation frame. It's just really a framing issue.
Yeah.
We have recommendations, they may or may not be accepted, but I do think those policy questions are sort of the heart of what we did.
Leah, were you saying something?
Yeah, I was just going to say that, there was pretty strong consensus, I would say, in our prep meeting yesterday with Mark Tuft, with Kevin Moore, with Randy and the staff from OPC, that there is no real issue with the working group taking this on, and that it's a much more narrow set of the kind of 5.4 et al. Issues than the Closing the Justice Gap Working Group will be addressing. So, and I think that's what you will hear at the meeting on Monday. So, with that, I feel fairly comfortable. At least this is the regulation subcommittee's recommendation. The working group can do with it what it will, but you're not going to hear, oh, this doesn't make any sense, it's totally overlapping, from the folks who've been really in the weeds on the other process.
Yeah, the charge of the Closing the Justice Gap Group is much broader when it comes to Rule 5.4. They're considering fee sharing with non-licensees of the state bar, someone who is, has never been trained, has any legal training, or is authorized to practice law on their own, including corporations. So whereas what we're talking about is actually allowing the type of fee sharing that happens among lawyers with another type of licensee within the state bar, which would be a paraprofessional. So that's why they don't see it as being a conflict between the two charters. But that it's a big decision, because not only is 5.4 affected, the minute you have paraprofessionals even practicing in the same law firm with lawyers, it's going to affect several of the lawyer rules around conflicts of interest, ethical screening. There's a number of supervision rules. There's a number of rules that it's going to touch on, and it's going to reverberate a bit.
Right.
So ultimately, the final package of rules that will have to come to the court will not just be a new set of rules for paraprofessionals. It will be revisions to the lawyer rules as well, if these are the recommendations.
And also controversial, also maybe equally as controversial, is the referral fee discussion, which really goes back to some similar policy decisions we're making. But paraprofessional who refers a case or a client to an attorney, or vice versa, has implications for referral fees.
That's right.
So I'm thinking that in terms of, organizing these by most to least controversial or significant, it sounds like we could take the section relationship between paraprofessionals and lawyers, but I would also think that we would want to put up in that category the pre-engagement informed written consent and the written agreement with disclosures. Those together, those seem to me to comprise either the most controversial or the most significant. Does that make sense as kind of a sequencing?
Yeah, I mean, again, Greg, I'm going to defer to you if you have a preference, because it sounds like you're taking the laboring or on presenting it. I think I would have a very different approach. I don't think we should be starting with the most controversial and the most difficult ones. I think we should be talking about the policy decisions we made first and foremost about written consent, written agreements, and informed consent. And those are things that we decided on a policy level are necessary to regulate paraprofessionals. They were included, several of them were included in the ADL's recommendation that we consider, and that we not start with, when we got into the rules, here are some things that we identified. It's like just higher level. Here's our policy decisions on regulation paraprofessionals, and this is how we're suggesting those be implemented.
Well, if that's the approach, I'm not sure I should be taking the laboring or that, because what I would be able to add is the fact that I highlighted these policy issues that underpin the rules for lawyers, so that you could consider them. I know that you also brought in some other, you considered rules in other jurisdictions that have similar programs, and we've stitched in some of the additional obligations into these sets of rules. But and as I think I said at our last meeting, what I can do is provide some background or some backdrop on the policy decision that you made. But really, the policy decision is your own, and it's not something that I'm not in a position as a court's liaison to advocate for any particular policy position, especially since ultimately I'm the one making recommendations to the court. So in terms of the way in which we would mechanically move through this presentation, is I would provide some background for when is informed consent required of lawyers, and what situations, and the regulatory subcommittee considered whether or not additional informed consent requirements should be imposed, and turn it to you and let you talk about the recommendation that you're making, if that makes sense.
Yeah, obviously, I really appreciate all your work on this and your willingness to take the laboring role on the presentation and explain the differences for attorney regulation. My preference would be, as I said, to start with the policy decisions, and I'm happy to do that with Fariba, and then have you explain why you're recommending the changes that you are recommending, to implement those policy decisions and how that requires changes from the attorney rules.
Oh, sure. I mean, yeah, that's fine. I can do that. So for instance, let's take the first policy decision you've made. You've decided that you want to impose an additional obligation on paraprofessionals to make certain mandatory disclosures and obtain a what are we calling it? Pre-engagement informed consent from a client right at the outset, the first interaction with a potential client. And so my recommendation to you is to make that part of the rules of professional conduct to the extent that you want it enforced through the discipline system, which is the proper place to put it. And where we decided to put that in the rules. So right now, the only mandatory pre-engagement disclosure imposed on lawyers is they must disclose if they do not have professional liability insurance. Therefore, that's one of the disclosure requirements that you are imposing on paraprofessionals. So it made sense to take Rule 1.4.2, which is the mandatory disclosure of professional liability insurance or absence thereof, and revise that to include these additional disclosures and the requirement to obtain informed consent. Does that sound like the approach that you want to take?
Yeah, that sounds great.
Okay.
So I'm a little confused here. I'm so sorry. So it sounds like, we're going to discuss the recommendations or what you have here as questions. So I'm not quite understanding this. I want to start with covering policy decisions and then move on to discussing the particular recommendations. Sounds like that's what we're doing. I mean, do you want to introduce this report starting with the policy decisions we made and then move into recommendations and start with the recommendations that we think are more controversial and end with those that aren't, just because of time?
Yeah, I think that was just a practical concern that we had, that we might not get through it all.
Right. So in stating our policy decisions, we're not really discussing the particular recommendations, just like an overview of the policy decisions we had to make. And then we move into each recommendation and then talk about the considerations.
Right.
Like
So, Fareed, I think
right?
we're on the same page. Unfortunately, I think that changes what maybe the plan was a bit and puts more work on you and I. But I think what I'm suggesting, I think what you're saying is these aren't going to be framed as questions anymore. They're going to be framed as our recommendations, and they're the policy decisions that we made. And Greg is going to then explain how he is recommending that the rules of professional conduct be revised to implement those recommendations, which doesn't, I think, require a lot of changes to this document. It's just, I think require Fariba and I to do a little bit more of the presentation.
Well, yeah, I mean, it's interesting because what we're talking about is really just the rules of professional conduct. The scope of the work that you guys have done as a subcommittee goes far beyond the rules of professional conduct. But all these policy decisions really relate to the rules, which are rules that impose standards, violation of which results in discipline. So I think we can preface everything to say these are policy decisions that you made around what is a disciplinable offense if a paraprofessional does not comply with these particular sets of rules, and then start with the pre-engagement informed consent, move on to the issue around contingency fees and how that can be enforced. And I can provide some background on, because contingency fees for lawyers are enforced not just by rules of professional conduct, because there's certain areas where they can't obtain contingency fees, what we talked about, but also the fact that they need to enter into a written agreement, which is governed by the State Bar Act. And the result of not doing that, it's a voidable contract at the election of the client. So that goes into the list of statutes that may need some attention eventually to incorporate paraprofessionals within the scope of that provision as well. So I think we would still be switching the baton back and forth a bit to provide some context for each of these policy recommendations you're making. ultimately, I think what we're looking for from the working group is feedback on each of these, correct?
Mhm. Right, and I think the questions they may have, you may be the only one who can answer those questions, Greg, because it's just so familiar to the level that at least I can't get close to.
Well,
So.
I'm very lucky in that I will have Randy D. from Durham on the call, Andrew Tuft from the Office of Professional Competence. I think Professor Moore may be there for the duration of the meeting as well, which will be very helpful. And hopefully Mark Tuft for a good amount of that early morning part. So we have plenty of expertise that's much deeper than mine that we can draw on if we start to get into the weeds and some of this stuff.
And is this going to be an overview? So there's no voting on the rules as they stand now? This is sort of still a placeholder to explain the process and where we are in the process?
Right, and to get feedback, with the idea being that a set of rules will come forward in June for a vote.
Yes.
And on the agenda, we're not even listed regulation subcommittee. So this is the part where it says State Bar Office of Professional Competence. Is that where we're discussing this?
There should be a
Busy
different
meeting.
title. Yeah,
Maybe
the
I'm missing
first
it.
agenda item, I'm not looking at it now. It has a very long title.
Oh, okay,
Yeah, that's this.
got it.
In terms of this written memo, I would just again urge that I really think that we've got to get the draft rules out sooner rather than later. And so my hope is that I can make modifications to this table. You can take a look at it, but that we not radically restructure the rest of the, switch question to recommendation, but not radically restructure the rest of the document, because that will take a lot of time. In terms of the presentation itself, the kind of PowerPoint, the mechanics of it, it can start with the policy decision with Freba and Amos, you two deciding who's gonna, take the lead on each. And then, kick it over to Greg to talk a little bit about the implications of that policy decision, what it meant in terms of codification in the rules. But that would just be my plea, because I think we will get a lot of pushback if we don't get it out sooner rather than later.
Right. And we're going to need, Justice Patru, we're going to need, probably some control over the time in the discussion, because each of these decisions and rule changes could turn into a bit of a rabbit hole.
Yeah, I mean, if you have, if you want to chart out kind of a rough, this is how long we should be spending on various things, I'm happy to try to keep everyone to that. I'm happy to get, a text or smoke signal saying, we're running out of time. We'll figure it out.
Do we want to, I think it might be helpful to quickly go through these questions and just make sure that we have accurately captured your position on each of these things.
That's great.
Because
Yes,
I think
please.
we went through these over a course of about 3 meetings fairly quickly. And so I just want to make sure that between Leah and I, we were able to accurately capture what your decision was. So I think with informed, can we start with we'll call it policy 1 now. Policy 1, I think that's pretty clear that we captured this correctly, that you want a pre-engagement informed consent that has a set of mandatory disclosures, and we went through the language on that already.
Yeah, I think that's right. Again, my concern is that this not be confused or combined with the separate written agreement and those disclosures. And again, you have it set up separately in the rules. I do think for clarification of this informed written consent, that we might want to specifically say this is to inform of the risks and alternatives to hiring the paraprofessional.
And that's in the rule.
Right.
So that's in the rule. I think that the issues that are going to come up from, I anticipate at least probably from Mark Tuff, is there's going to be some questions about the trigger for the obligation, that we have a clear trigger when it's required. We've already talked about, and I think we can, when this comes up, the idea of having a form that is generated either by the paraprofessional board or the state bar that can be used by the paraprofessional, so that there's no confusion about what disclosures are required, that language will be included, and it'll be similar to the disclosures for the mandatory fee arbitration.
And
Correct.
are we really calling it risks? It's just so negative rather than consequences or something like that.
Yeah, so this language thing is just, I don't know that we can do it on the fly, because I also don't think it's just an acknowledgement of certain disclosures. I think informed consent means, you know, something substantive, and the written form that we create is meant to be sort of confirmation that it was done. But an informed consent requirement means an informed consent requirement, not a acknowledgement of disclosures, which I think is different. So we can tweak this language, but I think you are capturing, and I think the draft rules capture what we were trying to do.
And that's why, Fariba, that's why I think it's going to be so important that there be a form that's generated, because I don't think we can leave it. It's fair to leave it to paraprofessionals to identify the risks appropriately. Because there are risks. Obviously, one of the risks can't be that you might receive incompetent legal services, because that's a risk that you have when you engage a lawyer too. So I think some of the risks that we've identified that will probably be in the disclosure is if your legal needs exceed my permissible scope of licensure, you may have to obtain alternate representation, something along those lines.
Yes.
Okay, and then going to issue policy number 2. Which is the written agreement at the initiation of representation. I think the trigger here is pretty clear. The rules fairly clear about what's required in that. There may be some discussion around fuzziness on some of the terms, but I borrowed, as you remember, I borrowed a number of provisions from the State Bar Act provision requiring written agreements for lawyers for anytime it's anticipated that legal fees will exceed $1,000. So there is consistency in that language. We should also just highlight for the group that these are statutes 6147 and 6148 from the Business and Profession Code. They're statutes that may need to be amended to include paraprofessionals as well. And again, 6147 requires a written agreement if it's a contingency fee arrangement, and 6148 if you anticipate that legal services are going to exceed $1,000.
So did we discuss the $1,000 minimum for written agreements? Because I'm
No.
not sure.
No, and
No.
this is Joanna speaking. I mean, when we've had the conversations in other groups and in the working group regarding a written agreement, there has not been any financial floor discussed as part of that I can recall.
Right. That's a floor for lawyers. So
It's not proposed for paraprofessionals.
Okay, got it.
we're not proposing that for paraprofessionals.
Okay.
We're proposing that they need to have a written agreement every time they engage a client.
Okay.
Some questions that you're probably going to hear from Mark Tuft and Kevin Moore, because there's an exception for lawyers in certain circumstances if they have an ongoing client relationship and the scope of representation expands. There may not necessarily be a requirement to enter into a new written agreement. So that may come up, and it may be something we want to consider later. Okay, going to policy 3, contingency fees. This may generate some discussion. I captured that you do want to allow contingency fees. They're permitted for the enforcement of final judgment actions only, and perhaps subject to a fee cap to be decided.
And I think we recommended a cap as well, right? At least as a placeholder in case there's, what was it, a third?
I
Oh,
don't,
in terms of a
I don't remember that.
I don't
I know
remember.
it was discussed. I didn't remember it as a recommendation.
I don't remember either. But it's definitely still subject to further discussion.
So I just want to make it clear, I would not be in support of contingency fees if there's not a cap. So my recommendation was along with a cap. Of course, a cap could be voted on what it is, but I would not recommend a contingency fee without a cap.
And I would be in agreement with that.
Okay,
All right,
so let's get
take
rid of
out
the
the
word
word
perhaps.
perhaps, yeah.
Exactly. This is why I wanted to go through these things to make sure accurately reflect
thank you.
the position. Okay. Policy 3, advance fees. The reason why this is important is because of the trust account obligations. So they are authorized to provide to obtain advance fees. The difference between the lawyer rule in this instance and what we're proposing for paraprofessionals are that there's an exception for lawyers that allow them to obtain informed consent. There's another rule where lawyers have to get informed consent if the client agrees to allow them to place the advance fee in their operating account. The rationale for not allowing this in this instance is because that carve out was to accommodate criminal defense attorneys and bankruptcy attorneys who were concerned that placing it in a client trust account could subject it to government seizure for the client and put them in a conflicted stance. So we do have that carve out for lawyers, but paraprofessionals are not going to be practicing in either one of those areas. So there's no need for the exception.
Right.
Okay. And I'm just highlighting that IOLTA statutes would need to be amended to include paraprofessional trust accounts within the scope of the program. Okay. And that policy 5 is really what we're just talking about too. It's dealing with the exception of placing it in their operating account. So we're authorizing advance fees, but we're not authorizing this exception. All right. Can paraprofessionals charge true retainer fees? No, that's pretty simple. Right. So that means they can never designate any fee, advance fee that they received as earned upon receipt or non-refundable.
Okay.
Okay. 7 was whether or not paraprofessionals can pay personal or business expenses owed to third parties with advanced funds, and we said yes. Subject to the same exceptions under the attorney rules.
Just backing up onto the true retainer fees,
Mm-hmm.
was that I kind of remember this discussion, was that based on a consumer protection concern?
Well, true retainer fees, there has been a lot of confusion among the lawyer population in California about true retainer fees.
Yeah.
We've often seen lawyers accept advance fees and call them non-refundable, and then place them in their operating account. And the definition of a true retainer fee is it's a fee that's just paid for the availability of the lawyer at the client's behest. So very few lawyers are actually charging retainer fees or obtaining retainer fees. What they're really doing is getting an advance fee. They're calling it non-refundable, but so we're saying that we can't imagine that paraprofessionals will be in a circumstance in which they will be charging fees to clients just to make themselves available at the client's request. It's such a rare instance even for lawyers. So it's probably easier to just say no retainer fees and you can't designate anything as non-refundable.
Okay, thank you.
Yeah, in policy 7, what the rationale behind this for lawyers is it's to help it's to help, especially it's a access to justice issue actually. It's to help a lot of clients. It allows clients to lawyers to pay some fees on behalf of indigent clients, some of the exceptions to the rule. Also to make the repayment of certain costs and fees contingent on the outcome. So it's another form of contingency. So we're adopting essentially the lawyer rule in this instance. This next issue, number 8, is a undecided issue. And this may be a great opportunity to pick the brains of Professor Moore and Mark Tuft on this, because they probably have a good perspective on this. We're saying that paraprofessionals, so lawyers can enter into business transactions with their clients or obtain a pecuniary interest adverse to their clients, like a lien, if they comply with certain requirements. And that's, the terms have to be fair and reasonable. They have to be disclosed in writing. The client's given an opportunity to consult with independent counsel, and you obtain informed consent. I think where you were leaning as a group was to say no business transactions with clients at all. but it was undecided. And I think one of the issues that came up was this, if we're allowing paraprofessionals to enforce judgments, we heard from that one gentleman who was from the Association of Judgment Professionals, that they obtain assignments of judgments in order to enforce them on behalf of individuals. So, and sometimes they're taking 50% of the judgment. That would be probably considered a business transaction with a client if we have this rule in place. So we just have to decide whether or not we're going to allow this or not.
Is
So
this,
Greg,
oh,
go
sorry,
ahead.
go ahead.
No, please, Frida, go ahead.
I was just saying, is this kind of like the family law real estate lien, FLRP, or whatever they call that? If I'm gonna find the quote, actually, I'm just covered it the other night, but is this something like that where in a family law case, a family law attorney can record a lien on the real property of their client for payment of fees? Is that kind of is that the kind of situation we're talking about?
Well, I'm sorry, if it's a current client, yes. If it's not a current client, so the client relationship has ended,
Right.
they wouldn't necessarily have to comply with Rule 1.8.1.
No, for a current client to ensure payment of fees.
Mhm.
Is
So
that-
I think we actually decided this one to not allow this.
Okay.
Maybe we can talk through it real quick. I would definitely be open to other perspectives and expert perspectives, but I think what we did, particularly on your example of the enforcement of judgments, is expect that will be an authorized area of practice for paraprofessionals. And if they're allowed to have a contingency fee, hopefully there will be a cap on that contingency fee. And that is the preferred approach rather than the assignment, because then they're not acting as providing legal services. They're acting as the party if they get an assignment. So I think that in consideration of that example and broader considerations, that it would require these people who can't afford an attorney in the first place to get an attorney to, consult with, that we're better off with this as a no, unless we're convinced otherwise. And I think that's what we decided last time. Fariba, do you remember that?
Mm-mm. Yeah, I'm still just kind of trying to figure out what whether this applies to those situations where a lien is placed on, and this is called it's actually Family Constitution 2033. It allows for a family law attorney to record a lien as against the real property of their client, and it only encumbers their client community property share. So I don't know if this rule covers something like that, and whether paraprofessionals are going to be allowed to do that. Obviously, this will touch another code section too. Do you know what I'm talking about?
I do. And this would actually, so if it was a lawyer, this rule would cover that situation. So
Okay.
this is the type of disclosure that you would be required to make to your client. The terms of the lien would have to be fair and reasonable. They'd have to agree to it and be offered an opportunity to seek independent counsel. So what we're saying is, to the extent that a paraprofessional is representing clients in these types of situations, they cannot obtain that lien. I see.
So, okay. So in a family law setting, if the client has property, we're not allowing the professional to record the same type of lien that an attorney would be able.
Yeah, that would be considered a pecuniary interest adverse to their client. So it creates a conflict, essentially.
But attorneys are allowed. We're not allowing paraprofessionals.
Attorneys are allowed as long as they comply with that rule.
We are allowing?
As long as they comply with Rule 1.8.1, yes.
Okay.
They have to comply with it, though.
Right, that would require a statutory change, I think, perhaps to 2033, but I don't know.
Well, we'll have to look at that. We should put that here. I'll make sure that we put that on the list of potential statutes. I don't know that statute off the top of my head, so I don't know if they refer to attorneys rather than represent.
It is a family, I believe it's family law attorney real estate lien or real property lien, FLRP.
I don't know if that would be a necessary statutory change if the recommendation is that paraprofessionals can't obtain such a lien. Because if we,
Right,
if we have a rule like what Amos is suggesting, if we have a rule 1.8.1 that is framed differently, that says you can never enter into a business transaction or obtain a pecuniary interest adverse to your client, to your current client, or however we want to frame it,
Right.
they would never be able to do that.
Right, and that could be default position of the working group, and the family law committee may have to look at it in depth because it's an access to justice issue. Sometimes
Right.
the client doesn't have access to funds, but for the community property house that is, subject of litigation, and attorneys are allowed to record. That's the purpose of that code section. It came out of a California Supreme Court case. Anyway, so or
And
legislation.
there are other examples you could probably think of where it is beneficial to a client to be able to enter into a business transaction with their lawyer outside of the representation agreement, which is separate. But what if we have a bright line ban on paraprofessionals doing that with their clients, then it's a ban. I mean, the reason we have the rule is because we recognize that it could create a conflict, and to provide a protection to the client, because it is in some instances beneficial to the client to be able to sell their car to their lawyer in order to pay fees or something like that. Then we wanted to make sure we had these ethical constraints on the lawyer, so they're making sure that the terms are fair and reasonable. I mean, that's a big one, right?
Right.
Fair and reasonable, disclosed in writing. You're letting them obtain independent counsel and giving them time to do that, or they're represented already by independent counsel, and you're obtaining their informed written consent.
Right. And the clients, especially in family law, are in a vulnerable position and they need the service. So I totally understand the restrictions.
This is why I had it as undecided, because I know Amos, your position was no, and I recall Fariba, you were undecided.
Yeah. Well, we can talk about it more.
And again, I think it would be helpful to hear from Mark Tuff on this, because I think he has and Randy, actually, they have a good idea of why this rule's in place.
And could you take a look at that code section and see if it's at all relevant here?
Yeah, I wrote it down. I'll definitely look at that.
Thank you.
Okay, let's move on to number 9. Loan money to existing clients. I also had this as undecided. This is similar to the issue we were just talking about. It's permitted in some instances as an access to justice issue, or some clients want to obtain loans from their lawyers, but we just wanted to make sure if they do that, that the lawyers are complying with the rule that we have in place for that under Rule 1.8.1 and 1.8.5. So I'm not sure. I think you wanted to get more information about this, and this may be a good opportunity to do that from the group that's going to be on the call. Can we move on to 10? I'm just hoping we can get through the list in the next 22 minutes. Solicit a substantial gift from a client. Rule 1.8.3 has a pretty bright line ban on soliciting a substantial gift from a client, either on behalf of yourself or someone related to you, with the exceptions being if you're related to the client. There's no need for the second part of that rule, because it deals with an additional prohibition on drafting an instrument that conveys a substantial gift, but paraprofessionals will not be authorized to draft those types of instruments as far as we know. So we don't need that part of the rule. 11, purchasing property at a foreclosure or judicial sale. Can they do so? No, and we're following Rule 1.8.9, which prohibits a lawyer or anyone affiliated with a lawyer from purchasing property at foreclosure or a judicial sale under these circumstances. I think there was a question about whether or not this is necessary. I think it's still necessary, because even though paraprofessionals may not be able to represent a client in these types of matters, they can be involved in these types of matters as a trustee, a conservator, a guardian. So that the rule is more, it goes beyond just a representation of a client. There is an exception, though, that it's cited under the lawyer rule under the probate code, but there's a you have to comply, the court has to authorize the sale. And there's a whole number of hoops that you have to jump through in order to comply with probate code sections 9880 through 9885. 12, this may generate some discussion, whether or not a paraprofessional can represent organizations. There may be some in the group that feel that we should allow them to represent small businesses or even nonprofits. So I'd imagine you're probably going to get some questions about that. I wasn't privy to that conversation because I missed that part of the meeting. So,
So in the case types that we're allowing, I think we had the, maybe we started talking about this when we were at the end of our last meeting. So I was trying to envision in the top areas of law that we're allowing paraprofessionals to deliver services. So where would an organization fit in there? So evictions?
Or enforcement of judgments.
enforcement and judgment.
Okay. And is it the other ban? Like no, or are we going to consider size? I mean, can we discuss it now or is it for later?
Well, I think we discussed it at the last meeting and I think you both decided no.
Yeah, I think this is just our reporting. I think these are just reflections of what we have discussed and decided already.
Yeah.
Okay. I
Yeah.
believe you.
13 should be, I think, fairly, well, hopefully, non-controversial, whether or not paraprofessionals should be permitted to provide limited scope representation. This would require actually some changes to the rules of court to permit this, permit unbundling of legal services. I think it's probably, personally, I think it's probably a good idea because it is intended to provide lower cost legal services to clients. It does affect certain rules of professional conduct. So, for instance, Rule 1.2b, which permits a lawyer to limit the scope of their representation without. This is one of those rules where we're providing more guidance and actually establishing a disciplinary standard. As long as they obtain informed consent. There's another example of where you have to get informed consent. Now 14,
I'm sorry, do the current rules, I wasn't aware of this, do the current rules limit this kind of services to family law?
No, there's a general limited scope set of rules for civil matters under rules of court 3.35 through 3.37. And then there's a specific set of limited scope rules under rules of court rule 5.425.
Okay.
Yeah.
Thanks.
Okay. 14 is co-owning, just among paraprofessionals, co-owning the same law firm. Probably not as controversial as the other issue around co-owning with lawyers.
And Greg, should we call it a paraprofessional firm, not a law firm?
I don't know. I mean, they are practicing law, so
Okay.
I don't know. I mean, it depends. If we decide that paraprofessionals can only practice with each other and support staff in one firm and not practice with lawyers, we may need to come up with a new term, because the term law firm and firm is defined under the lawyer set of rules in the terminology. So we would need to make a distinction between law firm or the term firm as used in the lawyer rules and the term as used in, because it's a term that's used in many rules. Firm, especially the conflicts of interest rules, ethical screening, those kind of things. So it is a name that will make a difference. So this is another area in which the decision to allow lawyers and paraprofessionals to practice together in the same law firm is going to affect several different rules on both sides. But this is accurate, the recommendation that yes, we are allowing paraprofessionals to practice together.
Yes.
And then 15, it is really just capturing the fact that they can sell their interest in the law firm to another paraprofessional. I have or lawyer, which is kind of reflecting the upcoming issue around co-ownership. But basically following the same requirements applicable for lawyers selling law firms under Rule 1.17.
Right.
Whether or not paraprofessionals from different firms can split fees. The decision was that to allow this based on the same criteria that applies to lawyers, meaning that pure referral fees among paraprofessionals would be permitted. Right?
Yeah, this is, I think, along with 5.4, going to be the other highly
Yeah.
controversial one.
Yes. And then probably a lot of these issues next, which is relationships with lawyers, will be controversial. So because I think 17, I think there are probably some members of the working group that want to require that paraprofessionals work under the direct supervision of lawyers, which will impact many rules. Most principally the Rule 1.2 on the scope of representation, allocation of authority, and then all the supervision rules as well. Those are the ones that come to top of mind. Whether or not they can co-own the same law firm. And the answer was yes, the subcommittee has decided that paraprofessionals can hold less than 50% ownership in a law firm co-owned with attorneys and may supervise non-lawyer staff.
Does it make sense for the presentation to have sort of an outline or chart of what other states were doing? Because when we discussed that, you were referring to that. I don't know if that's
Sure,
helpful.
that's a good point. And I think especially Washington does a lot of this. Sorry. Okay. And then can they share legal fees as 19 with lawyers who are not in the same firm? And if so, under what circumstances? Yes, and the same rules that allow fee sharing among lawyers will apply under Rule 1.5.1.
Is that 19? Let me see. Yeah.
That was
Okay.
19. Yeah. Moving on to advertising and solicitation, whether or not the ethical standards that apply to lawyers should apply to paraprofessionals. The answer is yes, and additional obligations should be imposed. And that can be seen specifically under the paraprofessional version of rules 9.7C, I'm sorry, 7.2C and 7.3C, that they must, any advertisement or solicitation communications must be placed by a licensed paraprofessional regarding their availability, must include their name and contact information for the licensed paraprofessional or the law firm responsible for the content. The paraprofessional's license number must be included, and a clear and conspicuous statement indicating that the paraprofessional is not a lawyer. And that's true on the mailers that go out as well as any ad that's placed.
That's right. There was also a language requirement. Is that, I don't know that it
Oh,
needs
yes.
to be a summary, but I think it is captured in the draft rule.
Yeah, that would be good to include that there as well. I agree.
Is there a separate section that governs what goes in the caption of any forms or documents filed with the court? That's
That's
Is
going
there
to be
like a
rules of
separate
court.
section? What is it?
That'll be rules of court that we would probably need to look at.
Okay, but is this where we discuss it or no?
Well, since we're trying to focus on rules of professional conduct, we're
Okay.
not saying necessarily that if somebody doesn't include the fact that they're, a designation, I'm a paraprofessional on a caption in a pleading that's filed with the court, that they could be subject to discipline. I imagine they could be if they persisted to do that and it resulted in a sanction that would be reportable, which is another set of statutes that we need to amend to include paraprofessionals on what they need to report to the state bar. But normally that's policed through the rules of court and the judicial officer.
Okay.
Yeah. And then 21 is the runner and capper rule. This is a gap that we currently have. I imagine the gap again being under 6152. It's a crime actually to for any person to act as a runner and capper for an attorney, or for any person to solicit another person to act as a runner and capper for an attorney. and it's written that way for an attorney. So there is no statute that prohibits anyone from being a runner and capper for a paraprofessional, because it does the profession doesn't exist. So barring a statutory change, which I imagine will be included in the statutory amendments recommended by the group, we have added, and I did go back and add it into Rule 7.3 as an additional provision, rather than having it as I think it was 7.6. So when you look at the red lines, you'll find it there. Just to close this enforcement gap, to make it clear, it's a disciplinable offense for a paraprofessional to solicit anyone to, or to to provide consideration to anyone to act as a runner and capper for the paraprofessional, or for a paraprofessional to do so for another paraprofessional. So,
And for a paraprofessional to do it for an attorney would be prohibited as a crime under the Business and Professions Code, right?
That's right. So that we don't need to really address that, because that's already prohibited. But again, I think it's important to have it in our draft rules to just continually highlight the fact that there is this gap, and at least we're going to try to cover it in the rules, but ultimately it may be covered by statute.
Right.
So, and that's the 21 questions, 21 policies recommendations from the group that I had.
So I think I'm on board with this. Again, I think I would probably format it differently, and I don't think we had 21 policy recommendations. So I think what we had was, 5 to 10, and then the other ones were, okay, implementing that affects a lot of different rules. And so, I don't mind just creating a chart that we can use as a, put up on here's the policy, and then jump into this memo, or just revising this memo to sort of start with the 5 or 7, whatever it was, policy determined, because a lot of these are really in the weeds. And from my perspective, you lose the bigger picture when you're talking rule by rule, change by change, and comparing it to attorney rules, as opposed to the big policy decision that, there needs to be, a bond, there needs to be a written disclosure, there needs to be a written agreement. And there's just a handful of those that we decided higher level. And that includes being able to practice in the same firm, for example. So, I don't feel strongly, but I think it would be better to start with those policy decisions that sort of really guide this and not get caught up on sort of the rule by rule red line.
I'm a little bit confused, Amos, because I think these are the policy decisions that you made, because there are a whole bunch of other rules in the attachment that we're not discussing at all. So I think
your confusion is what I'm trying to avoid, to sort of make this clear. So we did not, can you just scroll up in this document? There's a lot of these where, just because Greg identified rules that need to be decided upon, we had that discussion and decided, but all these 21 are not on the same level. We started with 5 or 7 big policy decisions that I think we should address first and explain first. So we did not start with the rules of professional conduct for attorneys and decide where we wanted to make changes. It's just not what we did. We started with, should there be an informed consent requirement? Adels asked that question. Should there be a financial responsibility requirement? Adels asked that question. We decided that, and several of these we did decide at a policy level, but like this one, question 8, we do have to address it, but it wouldn't go on the list of 5 or 7 things that we decided as a policy matter. Paraprofessionals, need to be regulated for consumer protection. This was Greg going through the rules saying, this is allowed for attorneys, should it be allowed for paraprofessionals too? So in my mind, there's a very big, again, it's really what I started with, I'll end with. I don't think we should be starting with, here's the rules of professional conduct for attorneys, going through them in order, here's the changes that we're suggesting, because I think that flips the process on its head. I think there's some main consumer protections that, if we're going to stand up a new professional license for non-attorneys to practice law, need to be required. And there's the short list, and it's not 21.
So
it's
Amos, it would be helpful to know, because I know you sent those 5 rules back in October, the written agreement rule, the informed consent rule, prohibited acts, I believe, permissible scope, and what was the last one? Can't remember the last one.
It was advertising.
Was it advertising? Okay, so you sent those. You sent those. The informed consent and the written agreement. That's clear to me. That's something that we have incorporated into the rules of professional conduct that are different and distinct from what's required for attorneys. The prohibited acts and the permissible scope, I think we walk through those to say, yeah, that's actually a prohibition we have in the rules of professional conduct for lawyers already.
Exactly.
And, right. And like we crosswalked through those. So I'm not highlighting those as being policy decisions necessarily. If you want them to be, I think we should probably get a list of things that you believe are at bottom basic policy decisions that you made and where they're reflected in the red line of the rules now.
That's fine too. Yeah, I think that's a good point. I mean, fee limitations, we had a lot of, although we haven't landed on a recommendation, that's not something that came from a review of the rules of professional conduct for attorneys. It came from, a policy discussion of how paraprofessionals should be regulated. And there's a few of those. So yeah, I think, yes, we had several at the beginning where you said we probably don't need anything specific on this because if we're tracking the attorney rules, it's already covered.
Yeah.
So I think that's a fair point. My concern is just what I stated before. This is very detailed, gets down in the weeds, and suggests an equivalence maybe of each of these 21 recommendations. And so again, I think we might lose the force of the higher level policy decisions we made on how paraprofessionals need to be regulated. If there's a different discussion or with other experts or with the full working group or with public about some of these, that's totally fine. But I think not all of these are equivalent in my mind. And these came up because we just have to address them if we're creating a whole set of paraprofessional rules of professional conduct.
Well, they came up, I'm sorry, my video is off because my internet is bad right now, but they came up because you all needed to make a decision in order for them to be addressed in the rules. Some rules never were even brought forward to you because it was so obvious that they needed to be adapted for paraprofessionals and it was clear how to do that. So I guess, when we had the discussion previously about the presentation versus this report and focusing, kind of prioritizing within the 21, starting with, I was suggesting the most controversial, but perhaps we could start with the policy, the big policy issues, and maybe not plan to even get through all 21 in the PowerPoint because they're too technical and maybe you don't think they're worthy of discussion. But I guess I would just push back a little bit that they didn't all involve a policy decision because that's why they were brought to you. They couldn't be just a technical modification of the rules. You had to decide something.
Fair point. So I think that's fair. So again, I would prioritize them. This is not the order or the priority that I would suggest, because I think there's a handful of ones that we decided are absolutely necessary. We agreed on them. We drafted language for them. And then we turned to Greg and the professional rules to say, where do these go? How does it fit in? Some of them didn't need changes. Some of them did. And others were brought to us and we also have to decide if, a paraprofessional can make a loan to their client. Yeah, we had to discuss that, but that I think was sort of secondary or third, or fourth priority of we've decided these big ticket items, but we really have to make decisions on these others if we're going to stand up a whole set of professional rules.
I think it would be helpful to get from you, Amos and Fariba, what you think are the top 5 ones. I don't think it will be helpful. This is my personal opinion. I don't think it will be helpful to go through that rule like prohibited acts or permit and do the crosswalk to the rules of professional conduct where it's already covered, because I think that is getting more into the weeds than this to me, because even though I think it may seem like a bit in the weeds, this business transactions and obtaining pecuniary interest to you. I will tell you, you're going to get a lot of comment on this because this is a major issue, especially within the legal ethics community and the access to justice groups. So this is an issue, but I get what you're saying. Like, I think contingency fees are a big issue, co-owning firms, big issue, sharing legal fees, huge issue.
Right.
And I see that there definitely are 5 that will generate the most discussion, and we might as well get them up front. So essentially what we would do is get rid of this whole organizational theme that we have around paraprofessionals' relationship with client, paraprofessional relationship with lawyer. Just get rid of that completely and just say, these are the top 5 hot button issues. And imagine I know what those are, but it would be interesting to hear from, and maybe after this meeting, you can just email Leah what you think the top 5 issues are. And then if we have time, we could get through the other issues. I would say I would want to provide to the working group all of this information, because between now and June, we're going to finalize the rules. And I think there may be some members of the working group who have concerns or feedback that they want to provide on some of these lower level issues. And one way that we efficiently were able to do that during the Rules Revision Commission was to do those email compilations. So have working group members email into staff, and then the staff will compile the emails, and then you two as a subcommittee can move through those comments. We can work through them together between now and June.
And I know it's past 3 o'clock. I'm still a little confused about this whole policy consideration and policy decisions. To me, we worked off of a huge policy consideration of access to justice, consumer protection, and perhaps not putting too many barriers in front of the people who want to enter this profession. And from that, then we came up with these recommendations, and we are to discuss the top 5 most controversial, most important recommendations. I cannot understand the difference between why you call it, Amos, policy considerations, policy decision. These are our recommendations based on those. That's at least what I have in my simple mind, is, policy consideration. Here are the recommendation based on those huge policy consideration. So that's an introduction. Then we get into the recommendation. Does that sound like a plan? Because I'm just like
So
that.
I think we have a working plan. I think that this works. And yeah, I don't think it matters to debate whether each of the 20 are policy considerations, or not policy considerations. They're all recommendations. But I again, how we started this meeting, I think there are 5 or so, maybe it's 7, big initial decisions that we made for EBA, where we came up with language, we worked through proposals, and some of that language ended up in the final. Some of it, I think we were convinced, isn't necessary at all because it's covered by existing rules. But we decided those are the ways that paraprofessionals needed to be regulated, right? There needs to be financial responsibility. There needs to be CLE. There needs to be written agreements with disclosures, those high level things. And then we got this list of other things that if we're going to have a rules of professional conduct, we also need to determine each of these items to see, does it apply the same as attorneys, or are we recommending different?
Well, I think it's in the same construct, Amos. You're saying we have to have rules around financial responsibility. We have to have rules around continuing legal education so that they remain competent. We also want them to operate under a set of ethical rules.
Exactly.
And that's why we had to turn to the lawyer rules. We just approved them. And there are major policy considerations. There's only 70 of them for lawyers. There's only 70. And each rule, even though that some rules are broader than others, some are very specific and have a whole history behind them. I didn't bring you all 70. I really only am highlighting about 18 of the rules where I think there are major policy considerations. I agree with you that some of them are certainly going to be more controversial and will move move discussion up more than others, partly because some people may not just understand the other rules, but or not have enough background to put it in context. But yes, I don't think it's really breaking the workflow that you were doing up until this point.
No, I think that's right. I think if we framed it that way, look, there's 5 things that we initially discussed are essential. Then there's 18 other things that we have to decide if we're going to stand up this program and run through that. I think that's totally fine. What I'm worried about is, the separate requirement of informed consent that we are recommending as a consumer protection gets lost in a debate about 20 different rules and edits to the rules, right?
No, I think having them up front, which I think they are right now, is probably the best way to avoid that.
Right. Okay.
I just want to understand what we're doing. So Amos, we're revising the table. You want the recommendations or the policy issues reordered in the memo, and then but the majority of this discussion impacts the actual presentation versus this memo. Is that correct?
That's fine. I mean, that's fine with me.
And then the reordering, you are going to send an email with what you think are the top 5. Or
Happy to do that.
Or whatever. Okay.
And I might just create a chart that we can use for the presentation. Doesn't have to necessarily be part of this document, but the idea is there are, initial items that we tackled first at a high level before we jumped into the rules of professional conduct.
Okay. Fariba, sounds good to you?
Yeah, and I think that we could work together on either you send it to me and I'll take a look, or we could work together to come up with it. Time on Thursday.
And Amos, you do have that memo that I drafted that crosswalks the original 5 rules to provisions in the rules of professional conduct, if you wanted to use that when you're putting your chart together, if you're starting with that.
Yeah.
And do you all agree that it would behoove us to get this memo and the draft rules posted tomorrow? Because then what I'd like to say is we sort of are modest in the changes to the memo and focus on the presentation. Because Fariba, you mentioned Thursday, like that would be too late in my view to get the memo done and posted, given that we want to give the working group time to review the rules.
Yeah, I think it'd be great to post tomorrow.
Okay, so I'll try to get you guys a revised table shortly, and maybe
And just this is Joanna. I'm going to jump in and then I'm going to sign off because I'm late for my 3 o'clock. But I just want to say that I also think tomorrow would be good. We have had, understandably, a number of concerns or complaints, however you want to characterize them, raised by various working group members about not getting materials with enough time to really review them. So let's get it out if we can.
Okay, so I'll revise the table, and then Amos, if you can just quickly send the email with the ordering that you think makes sense, we can at least get the memo done.
Okay.
Okay,
Okay.
thanks everyone.
Yeah, everybody. Bye-bye.
Bye.